It's a medical malpractice trial. The case has just ended. The jury is now sent out to go deliberate. Can the judge go over to the defense lawyer and say, listen, the plaintiff's attorney has a fantastic case. I think the jury's going to come back with a huge verdict against you. If I were you, I'd go ahead and try and settle this case. Can the judge do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, the judge can do that. Now, the defense attorney, when he hears the judge make that suggestion, now a lot of things are going to go through his mind. He might be thinking, hey, did the judge hear something that the juror said that caused him, prompted him to come to me and suggest I try and settle this case before the jury comes back with a verdict? He doesn't know. And he's afraid to ask the judge that question. Is there something the judge knows that the defense attorney doesn't know, and that's why he's trying to get this case settled? He doesn't know. The defense attorney has to wonder whether or not this might be an ideal opportunity to try and settle the case. Because now he might be able to go back to the judge and say, Judge, my client is interested in trying to settle this case as long as we can do it for a reasonable number. If you can speak to the plaintiff's attorney and try and get them to become more reasonable, we'd be interested in resolving this case before the jury comes back. And now the judge would have an opportunity to speak to the plaintiff's attorney, and he can come back and say, listen, I think that if you don't settle this case now, the jury is going to come back with much less than what you asked for, or give you a defense verdict and your client gets nothing. If I were you, I'd take this case, I'd settle it right now. Can the judge do that? The answer is yes, he can. The judge can put pressure on both sides to try and convince them that the outcome is going to be different than what they expected. In these civil lawsuits, the judge is impartial. He plays no part in overhearing or listening or participating what the jury is doing. The jury does their own thing in their own protected room with a court officer standing in front. And now the judge likely has no idea, but the judge might be willing to try and help both sides negotiate to come to a negotiated settlement so they can resolve this matter, because no one actually knows what the jury will do. Even if you have the best case around, a jury could come back and give you exactly what you want. They could give you more than what you want. On the other hand, the jury could come back even with a great case and give you less than what you asked for, or give you nothing at all. There are many different outcomes that can occur when a jury ultimately reaches a verdict. And the reality is that nobody knows what the jury is going to do. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding in what can happen in a medical malpractice case here in New York. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you still have questions that need answers, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.